This road accident case established important principles regarding the apportionment of liability when a motor vehicle strikes a pedestrian. Teubner was a news photographer who had been sent out late at night after a heavy downpour in Adelaide to take news photos. He stopped and photographed traffic ploughing through a large puddle and was crossing the road back to his taxi. He was wearing a large grey overcoat. Humble, aged 75, was driving quite slowly. The rain had eased off, but the car was immediately fogging up if the windows were closed. He did not see Mr. Teubner until too late and struck him, causing permanent injuries, so bad that Teubner could not give evidence at trial. The first lesson from this judgment is that even in these circumstances, where the pedestrian was in an unexpected place, dressed in dark clothing, the driver still had a duty of care to avoid hitting him. Justice Windier said, "Whatever the explanation of the respondent's failure to see the appellant in time to avoid hitting him, a blurred windscreen, driving too fast in weather conditions that imposed a special need for caution, or mere inattention, it is, I think, more probable than not that he was not keeping a proper lookout in the circumstances and that this negligence was a cause of the accident." At the same time, though, the second thing to note was that the pedestrian too had been negligent in a way that had contributed to his own injuries. Justice Windier again said, "It may be that if he had been watching attentively and seen the lights of the respondent's car, he would not have started to cross the road when he did. It is reasonable to conclude that he was imprudent, and it is possible that he did not stop to look and did not notice the car because he was hurrying to get back to the taxi to escape from the wet and to get to the newspaper office with his photographs. He may have seen the car and miscalculated the time and space factors involved in him getting across in front of it, or assumed that the driver would see him and swerve out to pass him." In the end, the High Court found that the plaintiff, the pedestrian, was responsible for 1/3 of the harm he had suffered, and his damages were reduced by that amount.